Yes.
Any mention?
My lord, I like to crave my lord's indulgence. One matter is there, the criminal 482 matter, my lord. It's been filed yesterday. May I pray, my lord, be listed at the end of the bottom.
Tomorrow, what is the urgency?
My lord, this is a 409 non-cognizable offence, my lord, has been given, and they have summoned him today, my lord. That's regarding the former IG, my lord, AIG, my lord. This is a counter blast FIR, nothing else, my lord. And the same sections has been alleged against him, my lord. Counter blast by one of the inquiry committee. And
someone to appear.
My lord.
You appear. What is the problem in it?
My lord, 409, and there's no cognizable offence at all, my lord. Has no cognizable. It's purely an abuse of the process of law, my lord. And I'm praying, my lord. I'm praying for staying of the investigation, my lord. There's absolutely nothing, my lord. If my lord will read the FIR letter, my lord will very clear. Only on the face of the FIR you will see it's just to
You say it's
vengeance.
a non-cognizable offence.
Yes, my lord. That's just to wreak vengeance, nothing.
This is your lordship. Lordship, in fact, there is no urgency, your lordship, because he's aggrieved only by because the police had issued him a notice under section 141A, your lordship, just to appear.
This absolutely.
We can have it tomorrow.
Tomorrow. My lord, at the end of the bottom, my lord.
Tomorrow, your lordship.
Tomorrow.
My lord.
Obliged, your lordship.
May it please, your lordship.
Yes.
Well, I beg to mention item number 10. Well, in this matter, we are making an endeavor to settle. My lord, I am supposed to pay some levy to the government, my lord. My account has already been seized. Now the amount is almost around 3 crores. So, my lord, the endeavor is to at least, but we've taken times, my lord, almost for the last 3 months. So, my lord, I'll just take time one last time. If the matter is not settled, then I'll argue the matter, my lord.
No objection, Your Lordship.
Give me 3 weeks, my lord, at least.
No objection means if there is a settlement, then there has to be.
There will be a bearing on this, my lord, because the entire matter is for non-payment of, my lord, levy to the government.
In the settlement, what role the state has?
Well, the state has filed an FIR because I have not been able to. I have not paid the VAT, my lord. This is for a bonded. Warehouse, my lord. Some VAT amount was not paid, so the.
So we'll just say issue of settlement is still on.
Still on, my lord.
Yes, Mr. Gautam London. See, the confusion is what you write. You write KC or you write KC.
But KCH, my lord. Otherwise, there is confusion.
London Council for the petitioner. 6 for grant of further time in order to enable the party come to amicable settlement.
My lord.
Or that matter is already, that order was already there.
Already, previously, my lord, I had made a
Say
mention.
London Council for the petitioners admits that some more time is required in the matter as the process of settlement is still on.
Obliged, my lord.
Obliged, Lordship.
Council for the state has no objection. We have granted list after 2 weeks.
Obliged.
Yes.
Please, your lordship. I beg to mention item number 12, lordship.
Item number 12.
Yes, lordship.
Yes. What happened at item number 12?
I'm praying for 2 weeks time, lordship.
Yes, Mr. Shalai.
No objection, your lordship.
I'm for the appellant, lordship.
It's a criminal appeal.
Yes.
Why are you taking time in criminal appeal? Okay, on the request of the appellant, list this matter after 2 weeks.
Obliged, your lordship.
May I please, Your Lordship? I beg to mention item number 14 and 15, Your Lordship. I pray this matter may come up after 2 weeks, Your Lordship.
Why after 2 weeks?
I am only for item 14, Your Lordship.
Why after 2 weeks?
Personal
Any
difficulty, Your
interim
Lordship.
order in this matters?
No, Your Lordship.
There is no interim order in this. You have no objection.
No,
You have no objection. State is a party here. State is in both the matters we are appearing about. 14 and 15, both the matters.
Yes.
Okay, this also at the request of the petitioner list after 2 weeks. 14, 15, both.
Your Lordship, a similar prayer for item number 17, Your Lordship.
Yes.
No objection, Your Lordship.
This is also quashing.
Yes, Your Lordship. There's an interim order also, Your Lordship.
Same order. 17 also same order at the request of the petitioner after 2 weeks.
Much obliged, Lordship.
Obliged, Lordship.
May I please, Your Lordship, I beg to mention item number 11, Lordship. Due to personal difficulties, Lordship. Up to 2 weeks, Lordship.
Who is the other side?
I'm appearing for the respondent, Your Lordship.
This is what Nakma matter.
No, Lordship. JTBC. Non-payment of salary, Lordship.
Okay. This 11 also. At the request of the petitioner, list after 2 weeks.
Yes, Lordship. Have you opened it, Lordship?
Yeah, please, Your Lordship. Your Lordship, I beg to mention item number 13.
Yes.
Appeal for 2 weeks' time.
Yes. July.
Issue is pending, Your Lordship. Your Lordship, in fact, had passed
Oh, that is a matter of
Lordship.
Okay. On the request of the. That will come after 3 weeks, I think that.
Lordship, yes, and that matter is being taken up by the DB.
That is there today.
Lordship, yes. That is the
So look at the book. What out that side of this court will not understand.
So let it come after 4
it is
weeks.
there before the division bench today.
Lordship, yes.
Okay, that let it
Let it
come
come after 3 weeks.
3 weeks. That's on the request of the petitioner. List this matter. Yes.
Apply.
Obliged.
From supplementary list, item number 1.
Yes.
May I please, Your Lordship. In this case, my lord, in the last order, by order, I'm not reading the order here. 5/12/23, my lord, regarding the deed of compromise, because last time it was signed by 2 persons, all the accused didn't sign.
What is the matter about? What is the this is
This is
an application for
this petition we have filed for
quashing.
quashing, yes, my lord. And last time, my lord, because the deed of on the ground of there is a compromise. And the compromise, so and moreover the other section are comparable except that destruction of public property. And that also has been, everything has been done among them. And they have been compromised among all those things. And the work has been done. And there is nothing pending also anything more. And that is peaceful now. But however, Your Lordship, in the last, in the deed of compromise, there are 7 accused, I think 7 accused, and only 5 signed, or only 2 signed. So by order 5/12/23, Your Lordship
Where is
has
that order?
passed this order.
Where is that order?
Uh,
Order. Where is that order?
106, my lord.
106.
Yes, my lord. And it's your 15.
Okay. So now you have come up with a proper compromise.
Yes, my lord. With all the compromise and have signed with all.
Then the private respondents or notice you will have to go. Who will issue notice then?
The done.
There are private respondents.
Lordship, yes. I'm for one.
So we will issue notice.
Lordship, yes.
Yes.
In
Yes.
fact, Lordship, one
Yes.
aspect of the matter is, if Lordship kindly come to the cause title,
Yes.
respondent number 3, if I'm not, yes. Oh, no, he was not the signatory to the deed of compromise, Lord.
But then why this 3 is
I don't know why this 3 has
Three is
been added as a Lord. Then Lordship kindly come to the compromise.
who is 2? 2 is complainant.
Number 2 is the informant.
Wait.
Informant, and then number 3, the Dorvashnong so and so, represented by L so and so, but he was not a signatory to the deed of a compromise. Rather, he was made as a witness. Lordship kindly come to page 103.
Then anyway, it's okay. Let us that notice be
Lordship,
issued to
yes.
him.
Lordship, yes.
Let him come. We'll just issue notice. Let us see. Okay, hard. Assisted by issue notice. Returnable in 3 weeks. Mr. Andy Shulai along with Mr. Hein. Yes, correspondent number 1. The full stop. Then the petitioner shall take steps for service of notice upon the respondent number 2 and 3 within 2 days.
Apply, your lord.
List of 3 weeks. Yes.
Main list, item number 1.
Yes.
Lordship, print this matter may come at the end of the board.
At
As
the
I
end
say,
of the board.
consul's on next.
Okay. Okay. Call at the end of the board. Please come this side. Please come this side.
Lordship, conducting counsel for the state, Mr. S. has some difficulty, Your Lordship.
Today. So when do you want it?
After the week, Your Lordship.
We'll have it after a week then.
Okay. Yes, Lordship.
On the request made on behalf of Mr. Esson, Planet GA. This is matter after a week. Yes.
Item number 2.
May it please your lordship. Your lordship, here the rejoinder filed by the private respondent is not available with me as of now, your lordship.
Lordship, for that, I will make a submission. Lordship will have a look on the last order dated 4/6/2024.
Yes.
Now, by this order, Mr. P.R. Pascal, learned counsel appearing for the respondent number 2, submits that an objection on behalf of the respondent number 2 will be filed during the course of the day.
Yes.
And they did not file as on date. This practice, your lordship, will...
Till now they have not filed.
They are not filed. And this practice should be depreciated here. This is misleading the court.
that is
here.
not
and
at
the
all
court has
appreciable.
believed...
Exactly.
That's good.
We agree. The court is in agreement with your submission.
Yes.
This is something, this practice should not be there. Yes.
We,
No, but then that submission was there on the last occasion also. No, but then why did you make this submission on the last occasion? This is very, very improper. You are lawyer. This is something not at all appreciable.
There was some difficulty obtaining the signatures. That's why.
Not-
I had already submitted my.
See, when you make a submission before the court that the objection was would be filed during the course of the day, you make a constant submission, isn't it? Then
I'll be filing it.
this is not something not at all appreciable.
I've already served the copy to the petitioner beforehand.
You sharpen
I have
copy
not-
to the state also.
a token cost be imposed, your lordship, so that they know that something wrong is done.
Excuse them for this.
And because, I feel very bad that most of the cases they take the adjournment that we will be filing within the course of day and never
They
file.
do not do. They do not do.
They don't do.
And it reflects badly on the lawyer, you see, it's not on the
Yes.
party.
Yes.
That is something should be avoided. Anyway, just say, Mr. Give his name. So and so, Lana Council appear for the this one number 2.
Vice Mr.
Hmm?
Vice Mr.
Why you are not there? You have not signed power.
On clearance behalf, since yes. This one.
We'll list this matter for hearing, and the meanwhile you file it.
They let them file it. Yes.
I'll be filing the prosecutor.
Then I'll be filing rejoinder to that.
This is a criminal petition, what rejoinder it is. You are making unnecessary like a writ petition. Even filing of objection is not
His
at all
reply was also not called for.
let us see if there is something required, then we'll permit you later. But then you do not have to.
Yes, lordship. May
You see, things become. See, you will find that many files have become unnecessary. Bulk.
I appreciate that, your lordship.
It is just like a
Because
submission and counter
no,
submission.
he is filing affidavit. So I have to rebut it in case something comes up, or your lordship may hear it.
That we will see. If it is required, then definitely we will give it up.
Lordship.
Okay. On 4/6/2024, the submission was made on behalf of the respondent number 2. An objection on behalf of the respondent number 2 would be filed during the course of the day.
There is.
However, today it has been pointed out by Mr. V.K. Jindal, London Senior Counsel for the petitioner that in spite of the submission made on the earlier occasion, no objection has been filed by the respondent to in the matter till date. Mr. Give your name appearing on behalf of Mr. Pierre Pasquet, Learned Counsel, for the respondent to made a prayer. Do not say made a prayer. Submitted that the objection on behalf of the respondent to will be filed during the course of the day. Submits that an advance copy of the objection has already been supplied to the counsel for the petitioner. In view of the submission, list this matter for hearing after 2 weeks. In the meanwhile, the respondent to shall file his or her, he or she, his objection.
After
Oblige, Your Lordship.
I leave.
List the matter for hearing after 2 weeks. Yes.
Item number 3.
Much obliged.
Please, Lordship.
Yes.
Lordship, this require a little time, Lordship, for filing for objection.
On the last occasion also you have taken time, isn't it?
Yes, Lordship, it's just that the accused person is from Maukarwad. So we've yet to gain signature from him.
This application is for what?
Lordship, this is because a state filed an application under 311 that has been rejected. Against that order of rejection, we have come. So it's a question of law only. Where is this court to file the?
Lordship, just allow us to demonstrate our objection how the.
But on the last occasion, court has permitted them to file an objection.
Right, Lordship.
Once you have permitted them, then.
Let it be 1 week, Your Lordship, without fail. Let them file without fear.
Just 2 weeks' time is allowed, Lordship.
Okay, as requested by the Mr. R. Karkan, Learning Council, appearing with the respondent number. There is only one respondent.
Yes,
Lordship. Lordship, yes.
Learning Council, appearing with the respondent. Another 2 weeks' time is granted to enable the said respondent to file an objection in the matter. List accordingly.
Apply.
Item number 5.
Lordship, this matter is regarding the suspension of the ministry without hearing.
Yes.
Parties. Because joint request had been made on the last date to list today, Lordship.
Yes. So, yes. What is the case about?
Lordship, regarding the dispute regarding non-cloud and non-cloud clan, Lordship. So they say that there's error in the act. There's error in printing in the act, Lordship.
Oh, there is another case also filed.
Yes,
is it?
yes. They have to suspend the petitioner without giving opportunity being heard. They have suspended the appointment of the petitioner as mentee without a hearing.
You are a mentee.
Yes, Lordship.
Okay. So, when did you become mentee?
2018, Lordship.
2018.
Yes, Lordship.
And where is your sanad appointment?
The sanad is page 18, Lordship.
Page
18, annex 1.
This matter, no notice has been issued. Notice has been issued to the other side.
All parties are. They have.
I have filed a caveat,
Caveat discharge.
Caveat was discharged.
All the parties.
So all the parties are otherwise represented.
Yes, Lordship.
Let us see. What is the? This has been continuously adjourned.
Yes, because there's an interim prayer, Lordship, staying the suspension.
One. Oh, this notice was issued in this matter.
Yes.
All the parties have accepted notice.
Yes, Lordship.
Nobody has filed their reply. Any affidavit of opposition? No one has filed.
You could be filing it. The only thing is that since your Lordship had fixed the matter
for consideration for interim period.
Interim.
Okay.
Otherwise, my lord,
there is urgency in this.
Urgency, my lord,
See, my sanad has been stayed without giving me opportunity of hearing. Stayed directly, Lordship.
Okay.
So in the first round of litigation in the single bench, Lordship, the is clearly reflected it be confined only to non-cloud and non-cloud as serial number 5 of the act. But this council has decided the matter, Lordship.
Yes, you want to take over? Take over. He's shaky since he's looking that side. So why Paul is not here? Yes. Yes, Mr. Paul.
Let's, as my learned friend might have pointed out, the limited issue here is that after the matter there was an order passed by the learned single judge of this honorable court, allowing the district council to take a decision whether it should read as non-cloud or non-cloud ringi in the act.
Where is that order? Where is
Well, I'll take a look.
Just take us to the operative part. Yes.
No, I'm sorry.
Just page 186, I think.
No, it's 186.
185.
Para 15, if I may read.
Yes.
However, without going into the merits of the matter and the propriety of either Nongklau or Nongklau Ringi figuring in Schedule 2 of the said Act of 2007, the resolution of the Executive Committee of KJDC of so-and-so
17, I think will be.
Malaj so-and-so is disposed of by directing so-and-so to take a reasoned decision in the matter as to whether the reference in Schedule to the relevant act has to be Nongklau Ringi or Nongklau, or only Nongklau. Such decision will be taken within 4 weeks from the date of the first hearing of both the petitioners herein and the respondent number 6 or their authorized representatives. In case it is the legislative wing which is deemed to be an appropriate authority to take a call, a select committee of legislators may be formed by the Legislative Council to hear both the petitioners and the respondents and so-and-so minutes. Then the matter was disposed of.
Yes.
My lords, thereafter, if your lordships may kindly come.
Now, issue was only confined to
whether it should be Nongklau Ringi or Nongklau.
Decision with regard to whether it should be Nongklau Ringi or
Nongklau.
Nothing beyond that.
Nothing beyond. Now, what the district council does is, my lords, in the meantime, my lords, what had happened is we had this apprehension that the matter would be decided without affording us an opportunity of being heard. We had come before your lordships, my lords, and I may draw your lordships' attention to page 191.
Yes.
Now, this is the last paragraph. If your lordships kindly have a look at it. Mr. So-and-so learned senior counsel appearing for the KGDC submits that the right of hearing is a basic right, and it goes without saying that the petitioner will be provided with an opportunity of hearing before the matter in question is finally heard and decided. Thereafter, my lords, the final order is passed by the district council, which your lordships would find at. Let's before that, if your lordships kindly have a look at page 197, the manner in which this order came to be passed.
Yes. Page 197.
197, my lords. This is a notice dated the 8th of April 2024 by the District Council, my lords. It says, with respect to the subject cited above, I have been instructed to inform you that an adjournment has been asked from the other party. The date of hearing for the other proceeding will be adjourned until further information and notification. So basically says, my lords, there is adjourned, the matter is adjourned, and you will be informed when's the next date of hearing. This is on the 8th of April. Now, on the 2nd of May, my lords.
Yes.
Without any further notice given to us after the notice of 8th of April, at page 199, if your lordships kindly have a look at Annexure 14. Now they say, my lords, with reference to the subject cited above and as per judgment dated 27/9/2023, passed in so-and-so, please find herewith the order dated 2nd May 2024.
When it was adjourned by notification dated 8th April,
my lords,
what is the stage of the proceeding there?
My lords, it was to be heard. We had made a prayer that you hear us.
Please.
It is my case that
you want to say that you were not heard.
Not heard. And that is borne out from the order itself. I'll take your lordships to the order at page 200.
Yes.
The matter has come up before the Executive Committee KG, if my lords have it, my lords. This is dated the 2nd of May 2024. Yes. The matter has come up before the Executive Committee KGTC by order dated 27/9/2023 passed by the Honorable High Court of Meghalaya and WPC number so-and-so, Donbok Nongklau so-and-so versus so-and-so, pertaining to the exclusion of Nongklau Ringi from Schedule 2 of the KGTC so-and-so Act 2007 by directing KGTC to take a reasoned decision in the matter whether the reference in Schedule 2 to the relevant Act has to be Nongklau Ringi or only Nongklau. As per direction of the Honorable Court, the Executive Committee by letter dated so-and-so fixed hearing on 2023 of all the parties, Donbok Nongklau Ringi and others petitioners, and Shi Damyang Nongklau and others respondents, in which both the parties also directed to file written argument and evidentiary documents in the said hearing. The preliminary hearing was conducted on 20/10/2023, where all the parties were present. It is in the said hearing, the petitioners were represented by the counsel who submitted written argument and orally briefed the Executive Committee as per customary practices. Nongklau Ringi was prevalent, and as can be seen from all documentary evidences available, his brief is in line with the written argument submitted. He also stated that in the bill passed by the House, Nongklau Ringi appeared, and on published in the official gazette, there was numerous error in which Ringi was missing. The representative from Nongklau clan informed the committee that they could not present the case to submit the written argument as directed, since they received the letter 1 day before the hearing on 19/10/2023, and also they were unaware of the said Honorable High Court order dated so-and-so. They also informed in the hearing that there is a Mintri duly appointed from the Nongklau clan. The meeting directed Nongklau clan to file a written argument on the next date. The executive committee in the order dated so also directed to serve a notice to Sri Yanan Onkla, who is made a party to this matter, and instruct him to file written argument. The Secretary, District Council, that is the petitioner before your lordship.
Yes.
The Secretary to the District Council Legislative Secretariat was also instructed to provide a detailed comments and documents relating to this matter. Shri Daming Noklau and others in the written argument dated so and so stated that Noklau is the clan which are there right from time immemorial and of their great grandparent, etc. And in fact, Noklau means clan. He also stated that Noklau Ringi is a clan in name only, which has no base or facts in it. And he stated that maybe Ringi is only the name of a village. Shri Yanan Onkla, who is a party to this matter and as directed by this committee, submitted his written argument, where he requested not to review the order dated so and so passed by the executive committee.
You have submitted a written argument.
Only a written argument, Malaj. After that, Malaj, we had prayed that you may hear us also. Because that was the direction passed by the single judge in the first place.
So it is not a total denial of opportunity. It's a partial denial.
Partial denial. But that is, Malaj, in the face of the orders passed by your lordships. Because when we had come before your lordships, Malaj, we had already submitted that I have given my written arguments, but I have made a prayer for oral hearing. Malaj. The Secretary to the District Council Legislative Secretariat, as per order dated so and so of the Executive Committee, submitted the observations and views dated so and so along with the enclosures, and on the direction of the Honorable High Court in so and so. In the said observation, it is stated the bill which was passed on 29/10/2007 in the Schedule 2 in the list of electors, Rongklau Ringi was approved by the House as introduced by the Executive Committee, and on being approved by the Honorable Governor, the office compared the original bill passed by the Council in session with the publication. Discrepancies were found, and amongst them, Rongklau was printed instead of Rongklau Ringi. It is the usual practice and perhaps a principle that supremacy and authority of the House is always respected. The hearing was again fixed on so-and-so, where both the petitioner and respondent were present and represented the council. The respondent, Shri Yanan Anklau, requested for adjournment, which was admitted so as to enable him to submit relevant documents, and in the said hearing, fixed for final hearing on 27/11/2023. After hearing the parties orally in the final hearing on 27/11/2023, in which the parties were present, including Mintri of Hima Milliam, they are once again given the chance to submit written arguments to substantiate further their claims and counterclaims on or before 15/12/2023. All the parties submitted the written arguments before the aforementioned date. They once again stick to their grounds evidences with regards to the matter. The Executive Committee, having considered the matter from all angles, perusal of the written arguments filed by the parties concerned, and taking into consideration the narrative above that the supremacy and authority of the House in its session is always respected. Nevertheless, there is no doubt that the Mintri of Hima Milliam is from the Nongklau clan and also known as the Mintri Nongklau. But as per records and customary practices in Hima Milliam, the said Mintri Nongklau is only from the Nongklau Ringi, which comprise of the four wombs so-and-so, 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 to be known as Mintri Nongklau Ringi. However, it is not necessary that the term Ringi is to be incorporated after Nongklau in the Schedule 2 of the said bill. So interestingly, my lords, now they say that since the bill reads Nongklau, let it remain Nongklau, but it would mean Nongklau Ringi. That's the purport of this particular paragraph.
No, how can they? That was not the.
That was not the direction of this honorable court.
See, what appears from the order,
my lords,
passed on the earlier round of litigation, they were supposed to take a decision whether the act should incorporate Nongklau or Nongklau Ring.
My lords, I am obliged.
Not to that.
I am obliged. Nothing beyond that. Nothing beyond that.
It was not their duty to say whether Nongklau would include and not how Nongklau.
My lords, you could not have improved upon the act, saying that, my lords, even though the act says Nongklau, it would mean so and so.
There no interpretation was needed for them. They were only required to give reason
whether it is Nongklau or whether it's Nongklau Ringi.
That must take a decision whether it's Nongklau or not, and then give reason why.
My lords, because it is on the basis of that, then the law would have to be amended.
As it appears from the nature of dispute, it was stated to be an error.
My lords,
this original bill contemplated something.
They say, my lords, it contained Nongklau Ringi. We say it contained Nongklau. The publication by the state government, my lords, in the official gazette, it was only Nongklau.
But the schedule in the act included Nongklau.
Only Nongklau.
And it continued for quite some years.
Long years, my lords.
Then subsequently, in 2018.
Lordships.
Now, when did you become a ministry?
My lords, I am appointed in 2018.
2018.
My lords.
Now, when this was first.
The bill, my lords,
was detected and corrected.
The bill. I'll just take your lordships.
You became in 2018.
18, my lords.
What is the precise date?
I'll just give the date of my son of my lords. My lords, 3/8/2018.
You begin.
My lords.
Where is that order of your sanad?
My lords, your lordships would find it
Let
at
us see what is the condition stipulated.
page
therein.
18 of this writ petition, my lords. Translated copy is at page 19. Your lordships have it.
Yes.
And we have the affidavit here. Just give me the date, page of the affidavit.
Your name was duly recommended by non-Auckland.
My lords. Now, all along, my lords.
Just a minute, Mr.
My lords.
Yes. Now let us assume if that district council order stands also.
My lords.
What would be the interpretation? Which way it disqualify you?
It does not, my lords. That's what my case is before your
Then
lordships.
why you are suspended?
For no good reason, my lords. And the Act, section 15, a query specifically fell
What
from
is
your
the
lordships.
impugned order? What is
I'll
the-
take your lordships to the impugned order. 209, my lords.
08.
209 is the typed copy.
Type copy. Translated copy.
Your lordships have it, my lords. By this, the Dorbar Hima Milliam, after receiving the order dated 2nd May 2004-24, which was informed
But
by
the act contemplates suspension of how many kinds? What?
my lords, the Act makes a very specific provision, my lords, that if
One
I...
is suspension pending inquiry and one is suspension by way of removal.
My lords.
No show cause notice was given.
Nothing. Section 15, if your lordships kindly have a look, my lords.
So this is obviously suspension is not pending any inquiry.
No, my lords.
What is the
Section 15 of the Act, my lords, of
Not a
2000.
suspension.
Your notice says...
Suspend the sanad.
Your lordship says the
It has the way
suspension
of
of...
suspending him only.
No, my lord.
So what is suspension of sanad?
No, it's not even suspension.
What it would imply?
Stop. The sanad has been stopped, my lord. I mean the.
No, what suspension of sanad means?
That would amount to operate.
Suspension. What suspension has no permanency attached to it. It is something temporary.
Well,
When you do something temporary,
well,
what will you do?
It has to be in contemplation of a certain
That
act.
means you are suspending him. Now you have done it temporarily. If you say that the passing of the order of the District Council has the effect of disqualifying him, then you should remove him, give him an opportunity to remove him, saying that you stand disqualified because of the order of the District Council. You have not done it. Yes, order is saying that just because District Council has passed this order,
on the basis of
you
the order
stand-
passed by this council.
that is okay. But then you say which way that order becomes a ground for suspending him.
Well, the order speaks very clear. the discounsel order. Your lordship comes to the
Well,
last,
it's the
last paragraph.
the perversity of the order of the district council is apparent.
That is under challenge also, Madam. That order is under challenge. But not in this repetition, Madam.
I had the same difficulty once in the other court.
This is a. We'll come back.
Madam.
Second call, item number 5.
Yes, where we
Only one question. Well, I was taking your lordship through the act. If your lordships kindly have the act of 2007, section 15 minutes. My lords have it. Well, it deals with term of office. The Basan, Mintri, Lingdo, and same ride, the Lingdo ride or the Longsan or the Red Relum or so-and-so shall hold office during his lifetime from the date of his appointment. However, in the event of any complaint against the functioning of the Basan, Mintri, Lingdo, the same ride or the Lingdo ride or the Longsan which prima facie disclose that he has violated any terms and conditions of his appointment, Sanad, or that he has violated any qualifications provided in the appointment, Sanad, or that he has violated, I'm sorry, Mills, or he has violated any qualifications provided in section 12 of the Act, or he has violated any of the customary practice or customary laws of the HIMA, or he has lost confidence of the majority of his clan members, or he has been conducting himself in a manner derogatory to his office, or which may undermine the authority of the executive committee, or he is found to be mentally unfit or incapable of carrying out his administration of the HIMA due to ill health, old age, or habitual drunkenness, the same or acting same and the executive darbar may, after enquiry, suspend or remove him from office and shall inform the concerned clan of the right mentioned either in Schedule 2 or Schedule 3 or to elect, nominate another male adult who meets the qualifications as provided in Section 12. Now, the proviso is very important, my lords, provided that the Basan, Mintri, Lingdo, the same right, the Lingdo right on the Longsan shall not be removed or suspended from office.
Any opportunity you have given him?
No, my lords.
I would submit, my lord, the Sanad, he is not under suspension, my lord. The order is very clear, my lord. And only the Sanad has been kept in abeyance in my respectful
under
submission,
what provision of law Sanad has been kept in abeyance?
Well, by virtue of the order which has been passed by the district council, my lord.
How? What authorizes you to suspend the Sanad? If you say Sanad is suspended and he is not suspended, what it would imply?
It has been kept in abeyance. I would say it has been kept in abeyance, my lord, not suspended, my lord. It has been kept in abeyance, my lord, by virtue of the order passed by the district council.
Suspension always is a temporary thing at a moment. You see, suspension cannot be taken as a permanent removal.
My
Now, suspension comes in two aspects. If you, as far what has been read out by just now, it is two things: you removal and suspension. Suspension comes when there is an allegation against him. But then you have chosen to use that is Sanad suspended. That means you have suspended him. Which way these are two different aspects.
Well, the difference is that, my lord, what they are saying is under suspension. What my lord is saying that it's under suspension. My lord, what I'm saying is that the Sanad has not been suspended. It has been kept in the abeyance, my lord.
But
by virtue of the
order
of
says
the
otherwise.
council, my lord. No, my lord, it doesn't say so.
You see, even if you keep it in abeyance, this is suspension.
A suspended animation would mean suspension.
Show us that you have given him opportunity. If you have not given an opportunity, that will be.
Well, that order has been passed by virtue of the order which has been passed by the district council on the basis of that order.
Whatever it is, your opportunity was needed. The act says opportunity is given. See whether district council order will have the effect of disqualifying him or not. That is to be decided.
Yes, my lord.
That order has the effect of
Disqualifying
him. He's not from the Noklau. He's not from the womb.
That four womb.
His name stands recommended by Noklau clan. The clan has not said that he is not fit man.
Yeah, it's long.
No, see. Do you want to say this Noklau Ringi clan is a different clan, and you'll have a different set of people to hold meeting?
Noklau is a overall common surname. And out of this Noklau, there is a womb.
We can understand that.
There are 3 or 4 wombs.
Yes.
What is visible to be the Mintri. Now, by virtue of that,
what the schedule of the act says?
By virtue of the schedule of the act, he came in the picture.
But then, what has been retained there? Even after the passing of this.
Noklau.
No, it says Longlau.
Noklau.
No, just
it says Longlau.
It says Longlau. It says Longlau. See,
please come back to the order.
See,
it says Noklau, my lords.
Even if you are not to accept the order of the EC, what has come into place now, what has been revived, is the term non-clouding. My colleague has not clearly made a submission.
No, see, so we have to go by what the High Court says earlier. High Court said you clarify whether it should knock or not. It seems you have not done that. You see,
What should we have done?
you have made it in such a way that both remains there. Okay, both are included. That was not your job.
Your Lordship, let me make a submission, irrespective of the fact that whether the order passed by us is right or wrong. But first and foremost, the issue in 2007, the proposal from the same of Millennium, the original proposal, that's why that original case record will be very important. The original proposal was Nokhlauringi. It came to the executive committee, we also accepted Nokhlauringi. It went to the House passed the bill as Nokhlauringi. When it went to DCA, District Council Affairs, then the Ringi.
You should have replaced this word.
Yes,
you have done that. You have not done it.
You have done it.
Where you have done it? Come to these things. They say it is not required.
Your Honor may have a look at Annexure 3.
You come to page 201, the last paragraph. What does it say?
Order, my lords, after the litigation. The order after the litigation.
Yes.
After the last round of litigation.
That is what is understanding. That is what. So why should we go before there? See,
before that is of no consequence anymore.
This dispute which you are existing, it culminated with the passing of the order by the single judge, where said you take a decision whether it should
Lordships.
knock or not.
Lordships.
So that is what
I bow down, my lords.
They should have said clearly. They should have clearly, instead of saying that it should be non-claw, but then it would include.
It would mean ringi.
How can it be?
It can't be. So once they say, my lords, it remains non-claw, matter ends.
The fact remains that you cannot retain two words together, two same thing together.
Let me come to page 185, Your Lordship. Let me draw Your Lordship to page 185. That is the decision of the single judge, Your Lordship.
Yes.
At para 16. As a consequence, the withdrawal of the corrigenda, page 185, Your Lordship.
Wait. Just go slow. Yes.
As a consequence, the withdrawal of the corrigenda by publication made in the Official Gazette on February 13, 2018. This February February 13, 2018 is also set aside. That would result in the corrigenda published on July 13, 2017 to be revived. However, in view of the further direction issued hereafter, the petitioners, that is the respondent, Nokhlauringi, herein will not be entitled to steal a march or obtain any irreversible benefit or adopt any irreversible measure. So here, Your Lordship, I just want
go to finish it. It comes back to the same thing. See, it is not that. It is not that. You see, that was stayed, and then only you see. Basically, that stay would mean that he is disqualified. No, it is not there. It is not there. No benefit was given. Both the things should be withdrawn.
Such direction is necessary in view of the order proposed to be made herein. What I'm trying to say here, Your Lordship, is that the non-clouding was the original term which was in the bill passed by the House.
Even then, you see, if whatever the thing, even if you accept your version also, a shock cause was needed. That is what has been contemplated.
Now, when the order dated 2nd May is very speaking order, until and unless that order is set aside and quashed, now the question of stay of the order passed by the same does not arise.
See, this court is of the view that even passing of the order by the executive committee does not have the effect of disqualifying the. And if you say so, then you have to give him a shock.
It's up to the same. What they say, what they do. He's the
No,
one
no, we'll stay.
He's no clouding.
Yes. What decision? What hand he had in decision?
He's the main.
No. So far as the decision is concerned, decision making is concerned. What was his role? What is your role? Instead of asking him, I should ask you.
Yes.
Whether your lordship is agreeable or not. What is happening here? The issue here, lordship, is with regard to non-cloud and non-cloud. Lordship, like my senior have submitted that it was it was proposed by the same amendment on clouding, accepted by the district council. It went to the house accepted. At the time of publication, there was an error. The word "ringy" went missing.
It continued, and that error remained for 10 years, almost 10 years.
So now, Your Lordship, what has happened is that when we filed a writ petition before the court, it was decided that it will go back to the. Now, Your Lordship, like the learned senior has read the order just now, saying that because after the mistake was pointed out, Your Lordship, there was a corrigendum that was issued in our favor, again incorporating the word "ringy." Now, the single judge order says the notification of 2017 should revise. However, it goes on to say that, however, in view of the further directions issued hereinafter, the petitioner herein will not be entitled to steal a march or obtain any irreversible benefit or adopt any irreversible measure that cannot be undone.
Yes.
Now, rightly or wrongly, the corrigendum that was issued in our favor is still operating. Still revived. Now, Your Lordship, after the matter was remanded back to the district council.
Now everything culminates with the passing of the order of the district council, which is under challenge. Why you're taking us to all those things?
No, I'm
Now,
Lordship,
just only we are
the
trying
question
to.
of hearing them does not arise, Your Lordship. Why? Depends on Your Lordship. Why is because, Your Lordship, if it was a case
Wearing them when? Where?
of hearing the
No, but then he was appointed as a
he was
military.
appointed, no doubt. Your
So
Lordship.
once you want to remove him or suspend him, you have to give him a
I'll
shock
come
house.
to that. I'm coming to that, Your Lordship. Now, my submission, Your Lordship, is that it's not a case where there was no proceedings earlier on, where the petitioner has just been suspended like that without any show cause. Now, this is a case, Your Lordship, where there were proceedings. He represents the non-cloud. I represent the non-cloud ringy. An order has been passed by the district council, hearing them. The matter was heard, in fact. It's just that the matter was heard twice, thrice, maybe 4 or 5 times. The petitioners came in.
So you want to say that requirement of section 15 will stand waived?
Your Lordship, in that case, Your Lordship, because the executive committee has gone into the
File your
customary
objection.
practice also.
You file your objection.
My Lord, even justice will not apply, Your Lordship, because they were heard before the executive committee.
See, it is forget about question of natural justice. This law contemplates. Even if we accept your submission is correct, okay, we will say. But then even that law requires.
But there's certain cases,
So
Your Lordship, where natural
you see,
justice will not apply, Your Lordship.
even there is nothing has been provided that even the situation is admitted also that provision of issuing notice will stand waived. That is not there. It's not provided.
I agree, Your Lordship, but we'll have to look into the facts of the case, Your Lordship. They were heard before the executive committee.
Tell us where has been when
issue here
show us
is
some law. Show
whether
give us
he was there or not.
give us some law under which this provision can be waived.
This,
We cannot go by hard.
One of the other aspect, Mohammed will see the order of the this council dated 2nd May 2022. That is not under challenge also, my lord.
No, that's under challenge.
It's not there, my lord.
No,
Not
it
in
is
this
in the
petition.
other writ petition.
Oh, there is another writ petition filed.
Not in this.
What happened to that writ petition?
That also, my lords, have directed, your lordships have directed affidavits by the other side.
There is no interim prayer made in that.
There is an interim prayer there also. my lords.
never pressed.
No, it is pressed, but your lordship said that let the affidavits come.
This is, my lord, your lordship's order is one.
Show me the order passing.
This suspension is a consequence of under challenge which was earlier.
Without.
The other petition.
It's not a procedural application of section 15.
Well, it's just one line of the orders, if I may just take your lordship's minutes.
There is nothing that has been.
Yes, there's nothing. my lord. Well, it's just one line, as your lordships have rightly pointed out at page 185. We all read everything, my lords, but one line has been missed out by all of us, from where this entire dispute stems. And your lordships have read, my lords, para 16, what was being read. Now, why I say, my lords, an interim order is required.
Yes. Yes.
I'll just quickly read para 16 again, my lords. Yes. As a consequence of the withdrawal of the corrigenda as made in the publication so-and-so is also set aside, this would result in the corrigenda published on so-and-so to be revived. However, in order of the further directions issued hereinafter, the petitioners will not be entitled to steal a march or obtain any irreversible benefit or adopt any irreversible measure that cannot be undone. That's part one, my lords. So the court is very conscious of this fact, my lords. Such direction is necessary in view of the order proposed to be made herein, since it appears that the legislative wing and the executive wings of the Autonomous Council may have been at loggerheads and may not have consulted each other, at least for the purposes of reference to the statute Nonkla or Nonkla Ringi. The petitioner should not take any precipitous step that may be difficult to be undone. And then your lordships have given us liberty, my lords, at
No, that is, see, whatever has been contemplated there, that is for the purpose of, you see, like
the order to be finally passed by district council.
Situation which was existing prior to the passing of the order of the executive.
My lords.
Now, after the executive committee passed this order, now this observation also gone.
My lords, in my humble submission, why I read this is, your lordships are correct, my lords. One view may be that, but why I read this is the intention of this honorable court, even at that stage, because your lordships had not decided the matter, was that let this position be maintained until. So now what is happening is, my lords, the matter is seized up by your lordships. The division bench is remanded.
Supposing if we say about that part also, see, if we say that okay,
my lords,
that whatever was contemplated paragraph 16 also
may have culminated into the final order.
Operation, see, operative value once that order came.
Now
come to that order. What that order?
There is nothing, my lords.
This order has the last paragraph. Have not said that non-cloud should not be retained. It should be replaced by non-cloud ringing. So that is good enough.
And my lords, the perversity of this paragraph is borne out by the affidavit filed by the same of Milliam, because the same of Milliam, my lords, at page 176 says there is nothing called non-cloud ringing. That affidavit is here.
That order is not under challenge also, my lord.
That order is under challenge and a connected writ petition.
See, just see, we are at this stage, prima facie stage. You find your reply, you know.
We'll find our reply, my lords.
Yes. Senior counsel. With the petitioner, and also just write all the names. This matter has come up for consideration of interim period. Mr. Paul Leonard, Senior Counsel, replying for the petitioner. At the outset. Points out the provision of section 15 of the Khasi Hills Autonomous District Council. Appointment of, just take it from there. Okay. 2007. And submits that the mandate of law requires that before MN3 is removed or suspended from office, he should be given an opportunity of being heard. He draws attention of this court to the impugn order and submits that petitioner was not provided with any opportunity before the impugn order suspending this order is at page what, Mr.
It's page 209, minutes. Last page.
Yes. What is the last name? Impugn order dated 20th May 2024 and submits that it is clear from therein that no opportunity was provided to the petitioner before his Sanad was suspended by the respondent number
Well, it's
Five.
five.
Stop. Your paragraph. The learned counsels appearing for the respondents do not dispute the fact that the petitioner was not provided with an opportunity before the impugned order was passed. However, they contend that the passing of the impugned order was necessitated by the order dated 2nd May 2024 passed by the Deputy Executive Member HDC by which the petitioner stood disqualified from holding the post of holding the post as a Ministry
of Nongklaukland before the same amendment.
Ministry of Nongklaukland. A perusal of the of record would prima facie show that the petitioner was appointed as Ministry of the Nongklaukland on being duly recommended by the Nongklaukland. Whether the passing of the order dated 22nd May 2024 by the District Council has the effect of disqualifying him from holding the post of Ministry of Nongklaukland is yet to be determined. So, even if it is assumed that the said order has the effect of disqualifying the petitioner from holding the said post, the law requires that he should be given an opportunity before any decision to suspend him is taken by the appropriate authority. Stop. Give paragraph. Since it is apparent that the petitioner was not given an opportunity before the impugned order was passed, it is deemed fit and proper to. What is your prayer, Mr.
And it's to stay the operation of that impugned order.
At this stage, give a comma. At this stage, it is deemed fit and proper to stay the operation of the impugned order dated 25/2024 till the returnable date. That will do your things. And then, how long you'll be needing to filing affidavit?
Within 2 weeks, we'll file it, madam.
Yes.
Well, the other aspect, madam, as I've raised, madam, that the order of the council is not under challenge in this petition, madam. In this petition, madam.
But then there is the fact means even if we assume that has the effect, the basis purpose is that you have not given an opportunity.
No, madam, if that is the case, then, madam, then Section 14 will come into play, madam. Then they have an alternative remedy.
Anyway, just all right,
Those will
you
be
file your
decided
reply.
in
You
those
just-
proceedings.
You file your reply. You just. What is the alternative remedy there?
We'll have to go to executive committee against the
It is
order
the
of the
order.
same.
No, but then when it is
Alternative
but
remedies, that was the law.
violation of enacted provision of law. That is,
Well, it is their case, well, that it is a consequential order of the executive
see the
committee.
recent order of Supreme Court, the availability of
Alternative remedy is not always.
when can it be a bar and when it cannot be. If there is an assertion that certain provision of law has not been followed, that can be a ground.
But the statute provides for that, madam.
And rightly, wrongly, the court has passed a new order. If you agree by that, you challenge it before higher. Okay, then as prayed for by the next paragraph, as prayed for by the learned counsels. This is matter after 2 weeks to enable them to file their affidavit in opposition.
Obliged.
Item number 6.
Yes. What is this matter?
It's about Nokma. Lordship, we were supposed to file the objection today.
Objection in what?
To the miss case that the respondent had filed, respondent number 4.
What? You are the writ petitioner, isn't it?
Yes, but here I'm the opposite party number 1 and miss case number 51 of 2024.
There's a miss.
Fix for them to file the reply to my application.
What is the application?
What has happened here in the year 2018,
Oh, there's an expiry proceeding
Yes.
against you.
which we had no knowledge for it.
You had no knowledge.
We contested the matter. They kept on asking for time. On the day when it was heard, they raised up this issue. Then I was taken aback.
So you have now
So I
filed an
accordingly
application
filed this application, Your Lordship, right from the
for
month of
recalling that order of expiry proceeding. And then you have to file an objection.
Your Lordship.
Yes, Lordship.
Now, when this application was filed?
April, 1st April.
So why you have not filed May? June? Yes.
Yes, Lordship, I did seek time for 3 weeks on the last date because we were not able to establish contact with the petitioner. Fortunately, we were able to do so just a Saturday through some acquaintances who stays
So you'll
in
be
Garden
filing
Hills.
it.
And he'll be coming this Friday, Lordship, to come and
So
sign.
when how long? How much more time?
I'm
you
just
need?
praying just for a week's time.
Yes. Okay. Mr. Raikewar, Learned Counsel, appearing for the in the miss case. This order will be in the miss case. 51 of 2024. Yes. Raikewar, counsel for the appearing for the opposite party. Praise for grant of further 1 week's time for filing an objection in the matter. The counsel appearing for the applicant has no objection. Share alert list after a week. In the miss case also, just say on the request of the party, on the request of the petitioner, list after a week. Oh, in the main writ petition, not miss case. Earlier order will be in the miss case. Okay, do not be confused. Yes.
Much obliged.
Item number 7.
Yes.
Mr. Ravi Gurung is appearing for the petitioner. Lordship.
Yes.
This is matter with regard to that visa of the petitioner.
Where is he?
He is there. He was here.
There is no one here.
He was here. And, just now also he was in the court.
None appears for the petitioner. Mr. H. Kharmi is present on behalf of the
Respondent.
Respondents. This is matter after 2 weeks.
Item number 8.
Yes.
The conducting counsel is in
This was petitioner. Yes. Yes, madam.
Lordship, they have informed us yesterday, Lordship. We
So
do
you
not
have no
have any
objection.
objection.
You have no objection.
No objection, Lordship.
How long? How long? How much time you want? You're doing it 2 weeks time. Are you sure? It should not be something like that. They repeatedly keep on asking time. Just on the request of the state respondents, solicit this matter after 2 weeks. Yes.
Item number 9.
Please, Lordship. Lordship, we have taken steps with regard to the new managing committee, Lordship, but the report is still awaited, Lordship.
Yes, number 8 is not
Your Lordship.
still awaited.
Yes, Your Lordship.
So what is to be done?
Lordship, we'll be filing the affidavit.
Have you verified status? No, not yet.
Not yet, Your Lordship.
So shall we wait for the service report or?
Your Lordship.
Okay. Okay. It has been submitted by the Learned Counsel for the petitioner that steps for service of notice upon the respondent number 8 has been taken, whereupon notice has been issued to the said responded by registered with ID. However, till date no service report has come. Stop. You just say await service report list after 2 weeks. Await service report on respondent number 8. Yes. Or await service report also will do. Await service. Yes.
Item number 16.
Yes.
On the last occasion, your Lordship was pleased to actually look into the orders in the criminal case. The case is that, Lordship, that State Bank documents deposited in the State Banks were not returned to the petitioner because of an injunction order, virtually injunction order of the criminal court.
Injunction order by criminal court.
Criminal court, Lordship. That was the case. Lordship, I would like to just point out the order sheets. Your Lordship, on the last occasion, wanted to see how the cognizance was taken in the criminal case.
Okay. Now, what is your challenge before this court now?
Challenge before this court is, Lordship, that order was passed by the learned CJM.
When that order was passed?
10 to 17, Lordship. 14, sorry, Lordship.
10 to 14, and this is under challenge now.
No, Lordship. Thereafter, other orders were also there. Ultimately, a revision before the learned session judge was also made, and that revision, Lordship, was dismissed in view of the previous order was not challenged. That is the reason, because two orders stand together. If one is challenged and if the
just if you take us to the orders, I think that will clarify the situation.
Status quo, Lordship. That
what
is
are these impugned orders? And
Lordship, may I kindly turn to the operative part of the order.
At page?
At page, Lordship, 15.
Page 15 of your petition.
Petition, Lordship. Fifteen.
Page 15 is a part of your. This is a part of your petition.
Huh? 28, no, 28 to no. No, additional hidden criminal. Oh, अच्छा 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 petition from court call. That is edition की Lordship Annex 2 at page 27, Lordship. More petition court call.
It's not.
Who is the respondent here? What is the relation between the petitioner and the respondent here?
We were directors of the Seven Sisters Plastic Company.
Both of you means like the petitioner and the respondent.
Yes, Lordship. Subsequently, purportedly, I have been ousted according to them, and we took loan for the company by mortgaging properties. With the State Bank of India, my personal properties were mortgaged, and the loan was liquidated summarily, Lordship. When the loan was liquidated, the documents were supposed to be returned.
Yes.
It was equitable mortgage, Lordship. Then, Lordship, may turn to page 29.
It was not returned to you.
Yes, documents should not be returned. That was at page 30, Lordship. It was the order passed by.
No. Then just tell us the facts, and then what happened after the
Then
loan
what
was
happened,
liquidated?
Lordship? Because of this order,
Your mortgage property was not returned.
Yes, documents were not returned.
Your personal property.
Personal property, Lordship. That is the reason why I have not been able to get back the documents.
Then what did you do?
And thereafter, Lordship, that order was passed behind back. Actually, it was
no. After your documents were not returned.
Yes, Lordship, we had filed an application before the learned CGM to vacate that order, and that was also rejected.
What happened in the court? You just come to later. Just give us the fact.
Fact is, Lordship,
you have told us.
Yes, Lordship.
That the loan was liquidated. Then it was for the bank to return your property.
Return the documents.
Then they did not return the documents.
They did not return in view of the order of the learned CGM.
Okay. Now, before your documents could be returned, the other side approached the court of CGM.
Other side approached
the court. Other side approached the court, and they obtained an injunction.
Injunction, Lordship.
How can that be obtained by from a criminal court?
That is the crux of the matter, Lordship.
And then what happened? Now this order was passed when? The criminal court passed an order of injunction, isn't
order.
it?
That is, Lordship may kindly see it at page 30. It is the typed copy of that order. Starting 29, Lordship. The operative part, I would like to, that will...
Page 29, yes.
29, it starts.
This is a case registered under what section of law?
Case, Lordship.
This CR case was registered under what section?
So many provisions, Lordship. I am coming to that.
Anyway, forget
one Lordship case number is 184. Lotus Hill PS. Thereafter, Lordship.
Sharma, you can sit down.
Before the learned CGM, Lordship, it is under section 120B, 403, 405. Your Lordship will find it at page 5 bottom.
Anyway, it's all right. And then what happened? Then this court come back to page 30.
Lordship. Page 30, Lordship, the operative part where the learned CGM has passed the order, Lordship, state finally holding that the concerned net fee Northeastern Development Finance Corporation Limited, Ganeshguri, Guwahati, as well as State Bank of India, Barneyhat branch, hereby directed not to release the original documents deposit.
Loan from two authorities.
Actually, not, Lordship. The case was filed that way. Documents were deposited only with the State Bank of India. That was a
And then
misstatement.
this order was passed not to release the documents. And then what happened?
Then what happened, Lordship? We could not get it. We had filed a civil suit also at Guwahati. Because Lordship, the Khanapara,
after this criminal matter,
yes, as the documents were not returned to get
after
back.
after this order was passed,
after this, Lordship.
so you filed a civil suit.
Civil suit also.
Civil suit. What is your prayer in the civil suit?
Civil suit was a declaratory suit, Lordship, to return the document.
For a declaration that you were entitled to
get back the documents, Lordship.
Then what happened to the civil suit?
Annexure 4, Lordship.
Then what happened to what is the status of that suit?
That suit is still pending, Lordship.
Okay. In that suit, they are a party? No.
A party, Lordship.
Are they a party?
Party.
They have taken part in that suit.
Lordship.
Okay.
In the suit they have filed, when the suit was filed, they filed one petition before the bank not to release the documents.
They filed the application there also that way, that not to return the documents.
Anyway, they are contesting. They are contesting. They are a party. They are
contested. Even in view of the civil court held that in view of.
Okay, and after this criminal court, your challenge before this court is with regard to the order passed by criminal court at Nagpur, isn't it?
Criminal court. Thereafter, we filed revision also. Ultimately, Lordship.
Challenging that order.
Yes, Lordship.
Then
there, that your Lordship will find that page. Annexure 6, Lordship, at page 45. That was ultimately dismissed, Lordship.
Annexure 6, page
45, Lordship.
Page 45.
Starts at page 45.
It was dismissed.
It was dismissed.
For what?
For Lordship, Lordship may kindly turn to para 11. No, para 11, Lordship.
Yes.
9 to 11, Lordship.
Yes.
I would like to take your Lordship to page 50 first.
Yes.
That having heard both the parties, the issues involved in this revision is with regard to the release of the original documents to the petitioner which he had deposited before the bank as additional or collateral securities for availing loan amount to the tune of 4 crores and cash credit of rupees 3.4 crores. There is no liability that was not deposited with sorry, Lordship, net fee. The learned CJM by an order dated 10/2/14 has directed the State Bank of India, Barnihad branch and the Northeastern Development Financial Corporation not to release the original documents to the petitioner till disposal of the case until further order. The petitioner has not taken any steps to vacate the said order because, Lordship, that order was passed ex parte in our absence, not on a fixed date.
Doesn't matter. See, we are
Lordship.
basically concerned with how criminal court takes cognizance of.
Yes, Lordship. That was the.
If it passes any order with the jurisdiction, that should be stayed. We will not go to the merits.
Lordship. Coming to that portion again, Lordship, the petitioner has not taken any step to vacate the said order, but in 2018, the petitioner, by way of a petition number 115/2018, has sought for a modification of that order dated 10/2/14 and to pass fresh order allowing the petitioner to withdraw the original documents, etc. And the petitioner before this court has not come to set aside that order, but has come only to set aside the impugn order by which that was rejected, Lordship, 13/9/19. And the learned CJM has refused to grant the prayer of the petitioner in petition 115/2018. The allegations against the petitioner in CR case number 5 of 13 is with regard to the misappropriation, diversion of funds of the company and cheating of the loan taken in the name of the company without its knowledge. The criminal complaint is pending since the year 2014. During its pendency, the respondent had approached the learned CJM to restrain the petitioner from withdrawing the original documents. That was the petition filed by the respondents, Lordship. In the next page, Lordship, the contention of the petitioner that the loan availed by the company has been liquidated and a letter to that effect was issued by the State Bank of India Barnihad branch. However, on perusal of the clearance certificate, there is a clear Annex 3, Lordship, in that application, that at 10/4/18 of the revision petition, this court noted that the same was issued by the State Bank of India Khanapara branch. As such, the branch name appears to be different from that as claimed by the petitioner. Here, Lordship, I have to clarify some points. But be that as it may, the respondent, while rebutting the contention of the petitioner, has submitted that the same original documents which were relied on by the company in procuring the loan from South Indian Bank, which were the same documents which was deposited to clear the loan taken from the State Bank of India Barnihad branch. That is the thing, Lordship. Here, your Lordship will be maybe to some extent find it rather confusing. But what happens, Lordship, when the loan was liquidated with the State Bank of India, at that point of time, prior to that, in fact, the loan was taken over by the South Indian Bank. But, Lordship, in view of that 10-2 impugned order, 10-14, Lordship, the documents were not returned. So, no.
Those positions were not clarified before the session judge.
No, Lordship.
Should have clarified it.
Which one, Lordship? Sorry, Lordship, this point I could not get. Anyway, Lordship, that is how there was no deposit of title deed with the...
Just finish the reading of the order.
After filing that petition number 115 of 2018, the learned CJM had passed the order that at 2012-18 directing the respondent to produce the documents to enable the courts to decide on the petition number 115. On 11/6/19, the respondent was again directed to satisfy the court whether the same documents was used as securities in the South Indian Bank, being the same loan payable to the State Bank of India Barnihad branch. In consideration of that petition, the petition number 115 filed by the petitioner, this court noted that learned CJM has passed several orders directing the respondent to clarify whether bank is in need of or not of the original documents deposited by the petitioner. However, no such responses were received by the court, and the same has made the learned CJM to dismiss the petition of the petitioner. From the contention raised by both the rival parties, it is apparently clear that the issue involves in the civil jurisdiction and a criminal court cannot overlook and exceed its jurisdiction. That was the observation made by the learned session judge in passing any injunction order restraining the parties. That was the observation. The allegations in the criminal complaint involves various sections of IPC and is deemed proper for criminal court to restrain the proceedings only with regard to the said complaint. The criminal proceedings has come to halfway only because the issue raised by the petitioner to withdraw the original documents has not been meted out. Counsel for the respondent has informed this court that the petitioner has instituted a title suit for recovery of his original documents from the bank, and the same is still pending before the learned civil judge Kamrup district at Assam. Therefore, this court has formed an opinion that the matter relating to release of the original documents from the bank, which shall be based from the outcome of the civil court or upon any direction issued by the civil court. At this stage, while considering the issues involved, this court is of the opinion that the liberty for releasing the original documents to the petitioner shall be at the discretion of the concerned bank when the bank realizes the loan amount or from the outcome of the civil suit. So with this observation, the criminal...
It was not for recovery of loan, isn't it?
Yes, Lordship. There is a no due certificate also, Lordship.
What is your prayer before this court?
To set
You are
aside
praying for setting aside those both orders.
both the orders, Lordship.
Yes, Mr. Sangma, how you will defend these orders?
Your Lordship, the EJM court has followed all the procedure.
How a criminal could pass an order of injunction?
He has made a complaint case against the petitioner in this case because what he said there is slightly...
Yes, sir, you please sit down. Just for a second. Let him we'll come back to you.
The respondent has given him some LIC of 1 crore something to get a loan from
See, do not go to the facts. This will be useless.
Okay.
Just satisfy this court how a criminal could pass an order of injunction, which is purely civil in nature, restraining one institution from releasing the documents. Whether bank was a party in that criminal matter?
No, Lordship.
No. Any official of the bank? Nobody.
Nobody.
So how this order could be passed? What is the order of the initiation of the criminal proceeding? The first order.
That is what your Lordship wanted on the last occasion
Yes,
to look
yes.
into.
You
And
have-
your
you
Lordship,
have a
yes,
copy.
Lordship, we have filed an affidavit also before your Lordship, additional affidavit recently, Lordship, that is with the order sheets. Lordship has got it.
Where is that order? The first order of the court? Or
First order, yes,
By
Lordship.
which which the process was issued?
Yes, Lordship. Lordship may turn to page 16. Initially, Lordship, the complaint was made over for disposal.
We want to see the order of issue of process.
Issue of notice, Lordship may kindly turn to page 9, where without taking cognizance, that is without examining the complainant even under section 200 CRPC, Lordship, the notice was issued.
Where is that order? Where is the
Lordship, page 9. Lordship may kindly see page 9.
Page 9 of your affidavit, isn't it? New
No,
affidavit.
yes, Lordship, order sheets are order dated, Lordship, 6/11.
Summons to the accused person fix 81. This is the first order.
This is the first order.
Yes.
Seen and perused the CR.
You see, nothing is there.
Issue summons to the accused persons.
Yes.
So, Lordship, without complying with...
In 2012, we do not know which way you have proceeded. You should have challenged it then and there.
No, Lordship, no notice were served.
Without someone, then how could you appear in this matter?
Lordship, thereafter, I would chronologically come to these orders, Lordship. Your Lordship will appreciate, Lordship, that on 10/8/113 also, Lordship, similar order were passed. But what happens, Lordship, the learned CJM was promoted and the new incumbent came in, Lordship, and thereafter the new incumbent, Lordship, may kindly turn to page 11. The new successor in office, Lordship, of the learned CJM, the then learned CJM, Lordship, 27/11/13, Lordship, page 11.
When did you appear before that court?
Lordship.
And once you appear before this court, instead of filing an application for vacating that order there, why you did not challenge the entire proceeding?
Lordship, yes, at that point of time, Lordship, the proceeding was not challenged for quashing, etc. Because the very...
What is your prayer before this court now? Just
It was appear on
Order 2,
2014, your Lordship.
Order 2. Prayer Lordship may kindly turn to the petition, page 16. Lordship.
Yes.
In the premise aforesaid, it is prayed that your Lordship would be pleased to admit this petition, call for the records of the case, and issue notice calling upon the opposite party to show cause as to why the orders dated 10 to 14.
So you also have only made a prayer for setting order these orders, not for the quashing, not for quashing the entire proceeding.
Not for quashing, Lordship.
Then that is what you should have made.
That is there.
Now, since you have not made this
No,
criminal
Lordship,
code
again,
cannot go beyond
Lordship,
that also.
Lordship may come to this. I am reading it out. Passed by the learned Chief Judicial Magistrate, Nongpo, etc. And the judgment and order dated 28 to 23. That is the revisional order of the learned session judge.
Just come to the part where you can show that this
Yes,
entire.
Lordship. Revision petition should not be set aside, and also the CR case number 5 of 13 be not upon causes being shown, and after hearing the parties, your Lordship be pleased to set aside and quash the said impugn orders dated.
You did not ask for quashing of the
Entire proceeding, not Lordship. Entire proceedings.
Then what would happen if you set it aside? Then it will go back to again to those court.
Lordship, because
what is the consequence? Say, supposing we allow you, we set aside this order. What
Lordship.
will happen to those proceedings?
Object is
So
Lordship.
that means those proceedings, the criminal court will have the liberty to pass any other order there.
Lordship,
Because this proceeding will remain there.
The basic object of this case, Lordship, is to get back the documents because the petitioner is a businessman and he is suffering from
But
hardship.
for that you have filed a civil suit. For that you have filed a civil suit.
Filed a
And the
civil suit.
revisional court has declined to interfere with the order of the CJM on the ground that this will be determined by the civil court. So once you obtain the order from civil court,
Lordship,
serve your purpose.
because ultimately, Lordship, the order of this honorable court will prevail over all other orders.
No.
Once this is
court
because
cannot pass any order touching the affairs of the civil matter. This court will not do. Civil court is initiated outside the state. So there is no question of this court interfering with the
those
proceedings
orders.
there.
Lordship.
So what remains here is that the order passed by the criminal court, which you have challenged.
Orders.
Maybe if this court is satisfied, okay, the court may set aside this order.
Proceeding
But
will
then the
run.
facts will remain. The proceeding will remain.
Proceedings will remain,
Then-
Lordship. Civil court at order decision as in view of criminal court.
Mr. Sagma, how do you defend these orders?
Your Lordship,
Do not tell us to the facts. Just tell us just how criminal courts.
there are many cases, Your Lordship. is to
Even
get
this,
the
even this revisional code
Yeah.
has found that this CGM has traveled beyond the jurisdiction in passing the order of injunction.
That's yes, Your Lordship. But in the judgment of the CJM, he has made out certain MFPCs that the petitioner here has committed some irregularity in depositing all those things.
Maybe that is a different thing. How can a criminal court pass an order of injunction?
The criminal court is passed as per the facts and circumstances of the
What allows the criminal court to pass? Show us any provision. In CPC order 39 rule 1 and 2 is there.
Yes.
In the criminal court where it is. Except for the proceeding executed before the executive court, the proceeding under 145, 107 CRPC and all.
Yes.
But then that orders are passed in view of the provisions laid therein.
My depend,
But
Your
then
Lordship,
in a regular case,
the proceeding has
which is
been followed.
instituted under certain provisions of IPC, how a court pass injunction, order of injunction. And we do not know also, Mr. You should have challenged this entire proceeding. That is something very wrong. And this court, unlike a writ court, cannot go and you see like mold your relief for. That is the law. That is the criminal matter. Whatever prayer you make, the court has to confine itself to that. Cannot go beyond that.
Lordship, it was 482 in a sense. Even
Cannot.
then, Lordship,
482
prayer, prayer is
Doesn't
not
allow.
there.
Prayer cannot be molded. 226 it can be, certain cases. 482 cannot be.
Yes. 227 is also
That is a supervisory thing, is a different
supervisory
thing.
thing.
But then,
Lordship, one thing may I point out, Lordship, in so far the impugned order is concerned, initial impugned order, Lordship, actually the cognizance was taken by order dated 27/3/14, 27/3/14, and the order was passed before taking cognizance.
now all those things are, you see,
No.
you should have challenged, you have not challenged the proceeding.
Because, Lordship, entire
So
orders
once
were
you have not challenged the proceeding, the issue of process is not under challenge. It appears that you yourself has succumbed to the jurisdiction of the CGM, filed an application therefore vacating.
Yes, Lordship.
Then
I agree. That is there, Lordship. Because of the Lordship, so many things here. The case has been, in fact,
Your Lordship, they have entered FPRN on
In-
3/1/2014.
that's okay, but then you cannot defend this order. These orders are not defendable. These orders will go, Mr. Singh. Nothing until unless you show us some law where criminal court can pass some injunction order. Otherwise, okay. That's fine, Mr. So, Learned Counsel, appealing for the petitioner, and also Mr. L.M. Sangma, Learned Counsel, appealing for the sole respondent. State is not a party here. You can sit down, Mr. Please. This application under 482 CRPC, read with Article 227 of Constitution of India. In your cost title, you say quashing of the criminal proceedings. In your prayer, it is not.
Not.
Anyway, what is it? Under 482 CRPC, Section 2 Constitution of India has been filed with a prayer for quashing the order dated 10/2/2014 and 13/9/2019 passed by. Now you do one thing. First you say, before you write 13/9/2019, after 10/2/2014 passed by the learned Chief Judicial Magistrate Nangpo in CR case number 5 of 2013.
Lordship, may I be permitted to just interfere a while, Lordship?
Yes.
In the page 17, Lordship, I read it as, and Quasdi said impugn orders in, but it is and, Lordship. I'm sorry, Lordship.
Which line? Which? Where? Which?
Page 17, Lordship, at the
Yes.
prayer portion.
Prayer portion, which line?
I am reading it, Lordship. 1, 2, 3, 4, 5, Lordship.
From the top.
From the bottom, Lordship, leaving the 4 line apart, Lordship, for the interim prayer. Then, Lordship, CR case number 1 be not causes shown upon such and such, and cause the impugned orders and the CR case number such and such, and or be pleased to pass. There is a mention, Lordship, that I read as in, orders in.
It should be in.
No, Lordship, I read as, mistakenly I read as in. It should have been.
This court has not got. Just a minute. This court has not got it. Please just say it. Tell what you are trying to point out.
Lordship.
See, just read these lines which you, where you say that there is a mistake.
And Lordship, from N portion, Lordship, last 4 lines can be not read, Lordship.
Okay, we are skipping last 4 up.
Then, Lordship, 1, 2, 3, 4. From Last fifth line, Lordship.
Your Lordship may be.
Yes,
Is it?
Lordship. Yes, Lordship. Your Lordship.
Please to set aside and quash the impugned say.
Yes, double. It was printed double, Lordship. Said impugned
Okay, there
orders
is no problem.
and Lordship and CR case number.
Quash the impugned.
Said impugned has been, in fact, orders have been twice printed.
And CR case number so and so.
And CR case number such and such. Lordship has got it.
So you want to say that this proceeding was this thing. You are speaking for.
Actually, there is a mention, Lordship, in the prayer. Not absolutely that there is no mention in the prayer.
No, but then that has not been done in a very clear way.
Your Lordship may consider kindly whatever it be.
Yes, Mr. Sangma. There is a prayer for quashing the entire proceeding.
This is only the impugned order, Your Lordship.
And then there is a.
That is what is pointed out. Proceeding is not there, Your Lordship.
That is what.
Proceeding is.
But, just a minute. What we said? You do not have to say the last line. Just say these orders. Praying for setting question of the and 13 and 2019. It passed by the Learned Chief Judicial Magistrate Nangpo in CR case number 5 of 2013, and also the judgment and order dated 22/2023 passed by the Learned Session Judge Nangpo in Criminal Division number 4 of 2019. The petitioner has also made a prayer for quashing the CR case number 5 of 2013. Stop. Give a paragraph. There is a police case also filed before this case. Is it corrected?
In Assam. Yes.
In Assam, Lordship.
In Assam.
Lotasil Guwahati, Lordship.
Stop. It appears so in materials on record that the CR case number 5 of 2013. Within bracket you write 2 of old. This is old number, isn't it?
Old number was 2, no? Old 2, Lordship. Then on transfer, Lordship, to the successor in office.
Just a minute. What is your CR case number 5 of 13, isn't it? Then you within bracket you write old 2/2012. 2/2012, close the bracket. Was initiated on the basis of a complaint lodged by the last minute hearing, wherein an allegation was made that the petitioner had committed an offence under section 120B stroke 403 stroke 405 stroke 406 stroke 409 stroke 415 stroke 416 stroke 418 stroke 420 stroke and 468 IPC. It appears that pursuant to the institution of the CRPs, the learned CGM by the order dated, by the impugn order dated where is that impugn order? First impugn order is at page
10 to Lordship, Annexure 2 in the petition.
page
Lordship.
19. Is it page 19?
Page 19 and 29. 10 to 14 is Lordship at page 29, the type copy, and otherwise Lordship at page 27.
The first order dated
Annexure
10 to 2014.
27.
Yes, yes. Just a minute. What you said by impugn order dated 10 to 2014. 10 February 02 2014. First, an interim order restraining the North Eastern Development Finance Corporation Limited. Within bracket you write NEDFI, Ganeshgiri, Guwahati, Ganeshgiri, and as well as the State Bank of India, Barnier branch, from releasing the original documents deposited as additional securities to the petitioner. Here. The said order was sought to be vacated by the petitioner by filing an application. Is it at page 36? Is it that application which you have filed?
Civil
For
application.
seeking vacation of the this order dated 10/2 was sought to be vacated, isn't it, by you?
Lordship.
Where is the application?
Oh.
Is it page 36?
36, Lordship.
That is what the court is asking. Please render him good assistance. The old man, he may not hear what the court. Okay, you sought to be what you said? Sought to be sought to be vacated by filing an application. Registered by petition number 115/18.
This is repetition.
No, repetition.
This is a petition.
Before CGM, we have filed petition.
But His Lordship is asking about the order.
When this application was registered?
It is on the top of the annexure 4.
That is all right, but then what is the see? There are 2
18.
filed on 27/9. Then within bracket you have written 28/8. Dates.
Actually, 27/9 is reflected in the order. Lordship, the petition was registered.
It is filed on 27 and 18.
Okay. Eventually. Just say.
It was 27, like say.
No, when you register, sir, do not write registered. Finally, registration, an application dated 27/9/2018. 27/9/2018. The do not say the say pursuant to the filing of the application. Final sign of the said application. The learned Chief Judicial Magistrate. Right. Another order dated 13/9/2019. 13/9/2019. Declined. What we said, just say this. See that this before that, just you say the petitioner filed an application seeking modification of what we said. The said order was sought to be modified. No, before they just start the line, starting of the line. No. Not pursuant to the before that, just come before to the line where we said that petitioner has filed an application dated so and so. Have we not said that petitioner filed an application dated 27/9 something? Or the just read that entire line, the beginning from that line. Okay. It's all right. It's all right. Now come to the last part. Now, what was given last part? What's the last line? Now, last line. Just now, what? Where we stop now? Decline to. Okay. Decline to vacate. The order dated 10/2/2000. What was the date?
13/9/2019. Annexure 5.
13/9 is we're talking about this. Okay.
Impugn order original 10 to 14.
10/2/2014.
10 to 14.
Yes. Stop.
But that order was not challenged in district court, district session judge.
Which order?
That 10/2/2014. They have challenged 19 only.
They have challenged only 13/9.
19. Order 19.
What is the 19? Where is the 19 again?
This page 41, you will see. Annexure 5.
Page 41.
Yeah. 41. Annexure 5. 13/9/2019.
Yes. That is the order by which the court below has refused to vacate the order dated 10/2/2014.
Yes.
So, now you want to say that this order has not been challenged?
Not in the session court.
Not in the session court. Now, session court, they challenge only the 10/2.
Yes.
Okay.
The challenge only.
But then
13.9.
before this court, now 13.9 is under challenge.
May I clarify? Before the session court, only order 13/9/2019 was challenged.
Yes.
Not that 12.4. Not
Not that
anyway.
10.2.
Anyway. What is the last thing just say? Pursuant to this petition, and after hearing the parties, just say and after hearing the parties, and after hearing the parties, we learn it CGM by, or sorry sir, declare. Stop. Give a stop. The petitioner being aggrieved challenge the said order dated 13/9/2019 before the Court of Session Judge in Criminal Division number 4 of 2019. Stop. The learned Session Judge right impugned judgment dated 22/2023 declined to interfere with the order passed by the learned CGM on the ground that a civil suit for recovery of original documents by the petitioner from the bank is pending before the civil judge, Kamruk District, Assam. And therefore, the court was of the opinion that the liberty for releasing the original document to the petitioner shall be at the discretion of the concerned bank when the bank releases the loan amount and it says or from the outcome of civil court. Now what it would mean? Or from the outcome of the civil. Give paragraph. Being dissatisfied with the side order dated with the said impugned orders dated 10/2/2014, 13/9/2019, and judgment and order dated 22/2023 of the session judge, the petitioner has preferred this instant revision petition before this court. Give a paragraph. The learned counsel appearing for the petitioner contended that the criminal court does not have power to pass any order of injunction in a matter which is purely civil in nature. That apart, give a full stop. That apart, it has also been contended that the very initiation of the criminal proceeding by the Court of Chief Judicial Magistrate is wrong inasmuch as the provisions contained in section 200 CRPC has not been followed before issuing process in the matter. Stop. The learned counsel also contended that the learned CJM has also not recorded the statement of the complainant. You are from out of station, isn't it? You do not reside in Shillong.
No, from Guwahati.
So it means that provision of 202 also should have been followed. That also has not been followed.
Yes, Lordship. At the time of passing
Because
that
you are
order,
house station thing. So in such a case,
Lordship, that is,
magistrate must order some investigation before.
yes, Lordship.
In addition to the recording of statement, or investigation has to be conducted.
Lordship. Two things could have been done.
Anyway,
Lordship.
Statement of complainant and three witness already completed.
No, that is issue of process, before issue of process. The court could not have issued. See, C200 says. Okay. What is it? Complainant prior to ordering issuance of summon to the petitioner, to the accused stroke petitioner herein. Which is a gross violation of enacted provision of law. He submits that even the session judge has failed to appreciate the fact that an injunction order, which is purely civil in nature, could not be passed, could not have been passed by the learned CJM in a proceeding which has been initiated under the provisions of Code of Criminal Procedure 1970. Paragraph. Mr. Sangma appearing for Mr. Sangma on the other hand, Mr. Sangma, learned counsel, appearing for the respondent on the other hand, contends that the impugned orders were passed after taking into consideration the facts and circumstances of the case, and after proper appreciation of materials on record, stop. He also contends that since there is no actual dispute insofar as the facts and events of the case is concerned, the impugn orders cannot be faulted with, and there is no requirement for this court to make any interference at this stage. Next paragraph. You see, just say. What is the order by which you were directed to obtain these orders, the initial order of the CRPs, and then place it before this court?
13.5. 13.5.
13.5.
In my additional affidavit, I have an annex.
It's all right. It's all right. We got it. Okay. What we said? Just next paragraph. Have you started anything? Just as per order dated 13/5/2024, passed by this court in the present proceeding, comma, the petitioner has produced the initial order passed by the court of CJM in CR case number 5 of 2013, by way of an additional affidavit. Stop. The perusal of the order sheet of CR case number 5 of, what is that number? 5 of 2013. Comma, it transpires that the learned CGM did not bother to adhere to the provisions of section 200 CRPC before deciding to issue summons to the accused. Previous to petitioner. Okay, accused petitioner. It is also not reflected anywhere that the complainant was examined prior to the issuance of the process, and there is also no order recording the prima facie satisfaction of the court. In the matter before the process, before ordering the issuance of process. That apart, there is also no law which empowers the criminal court to pass an order of injunction concerning a matter which is purely civil in nature. The learned counsel for the respondent has also failed to point out existence of any such provision. That apart, it is also noticed that the petitioner is not an ordinary resident of the state, and in that situation, it was incumbent upon the court of CGM to also adhere to the provisions laid down in section 202 CRPC. Stop. Then it's a provision. Then what is the starting? What is the previous line? Just the line. Okay. Sit down. So then you just say after full stop. In addition, section 204 CRPC mandates that before a criminal court decides to issue process, it is incumbent that the court records its primary satisfaction to the existence of sufficient reason for proceeding in the matter. Now, in the present matter, the entire order sheet of the CR case number 5 of 2013. You check this numbering from the file, okay? This number produced by the petitioner by way of an additional affidavit. No, produced. See, brought into record. Do not say produced. Brought into record by the petitioner by the additional affidavit do not show compliance of provision of section 200 wait just a minute. What we said, the entire order sheets. What is the last line? No, just last line. Yes. Compliance of any of the provisions of section 200, 202 and 204 CRPC. And hence the proceeding initiated cannot be sustained in law. Your paragraph just say in view of what has been discussed about the passing of the impine order, the very initiation of the proceeding, do not say passing of the very initiation of proceeding under proceeding in CR case number 5 of 2013 within bracket you write all 220 cannot be sustained in law. Consequently, the impine order stated (10 to 2014), then 39 2019. Is it?
Yes.
And no.
13/9/2019.
And what is the order of session judge?
And 28/2/2023.
Okay, so initial, then consequently, the order dated 210 so and so and 13 so and so passed by the CGM, and order dated 28. What is
8/2/2023.
passed by the
20.
28
28/2/2023.
23 passed by the Learned Session Judge is not tenable in law. Consequently, the order dated so and so passed by the Learned CGM Nongpo, and order dated so and so passed by the Sessions Judge Nongpo also cannot stand in the eye of law, and the same are set aside and quashed. Then you say this revision application stands allowed.
Deeply obliged.
There may be some clerical correction and all. You will just check it.
Lordship.
There's some other matters left.